Good afternoon. Today I will be discussing alternative dispute resolution and the processes that are enclosed in such practices. With alternative dispute resolution, there are several processes within this practice. However, today we will be focusing on specifically three uses of ADR in the entertainment industry. The three methods of ADR discussed today are arbitration, mediation, and early neutral evaluation. So, what is alternative dispute resolution? Alternative dispute resolution, otherwise known as ADR, is a set of processes that are actionable in reaching a settlement in a dispute, all of which are focused on avoiding litigation or taking a dispute to trial. According to Multa 2023, ADR is an effective method of settlement for various reasons, including its cost effectiveness, flexibility, confidentiality, and poses the ability to preserve relationships that would otherwise be destroyed through costly and contentious court proceedings. Many methods of ADR are in practice today, and most of us know these methods as basic negotiation, mediation, and arbitration. Here today, I'm going to focus on the most severe process of ADR via arbitration and work my way through the least intensive processes such as mediation and early neutral evaluation. Method 1, arbitration. Arbitration is the most costly and severe of the three methods discussed today. However, according to the American Arbitration Association, arbitration is still more cost-effective and time-efficient than pursuing a trial when considering a dispute. Arbitration is beneficial to many people's private affairs as it is confidential. However, it is not focused on the win-win strategies that other ADRs may highlight within their practices. There is a reasoned or bare bones award rewarded at the end of the arbitration, and one party is to receive a winning decision. Arbiters must be neutral, do not have to adhere to state or federal practices like a judge, and can issue binding and non-binding agreements. If a decision is reasoned, it is supported with reasoning in its decision, whereas a bare bones award does not require the arbiter to state how they reached their decision in the award. When it comes to binding and non-binding agreements, this is when the parties decide that the award is binding and a settlement is reached, or is non-binding and serves as more of an advisory form of a dispute resolution, moreover a settlement. In conclusion, arbitration is the most severe form of ADR because it really focuses on the fact that the parties involved have placed evidence, statements, and all facts of the dispute in the hands of the arbiter or the arbiter team of three and have no final say of the award that is delivered to the parties seeking this form of ADR. Method number 2, early neutral evaluation. The second method of alternative dispute resolution, and one that is much less intensive as arbitration, is early neutral evaluation. M.G. Kumar Law Firm defines early neutral evaluation as non-binding and is similar to mediation, however, is aimed at deciding a probable outcome of a case should it proceed forward to litigation. E&E is established after a dispute has been submitted for trial and is implemented prior to in such case that the parties can receive advice on how to settle before the case reaches full-blown litigation. Early neutral evaluation uses an evaluator who assesses both parties' strengths and weaknesses and is essentially the preemptive hypothetical scenario as to who will come out the winner should the case proceed. This serves as an opportunity for the parties involved to see the benefit in settling on a win-win basis and possibly moving forward with a mediator or even arbitration, so to avoid the lengthy and costly structure of court proceedings. It also provides an opportunity to choose what they feel may be best for both parties before it becomes a win-lose situation. In conclusion, early neutral evaluation utilizes an evaluator that assesses all evidence and materials, then provides a best look scenario for both parties should the case proceed to trial, and suggests less intensive measures should it not need to reach that point. Method number 3, mediation. The third method and most commonly known process of alternative dispute resolution is mediation. Mediation puts the control of the outcome in the parties' hands and really highlights the win-win strategy of both parties leaving satisfied with the settlement reached. The parties that decide on mediation feel confident in these matters staying private because, similar to arbitration and early neutral evaluation, this is a confidential process of actions taken. The mediator is selected by the parties and should always be neutral with no previous interactions with either party. Nolan Haley states in his book, Nolan Haley's Alternative Dispute Resolution, in a nutshell, that mediation's central value is self-determination. The fact that the parties get to resolve the dispute together is of primary importance to this ADR method. Dawson states in his book, Secrets of Power Negotiating, that the reason mediation works is because it helps both parties realize the process is non-binding until a settlement is reached, and at which point the process goes from advisory to a binding settlement of actions that both parties have felt an equal amount of contribution in reaching that stage of settlement. ADR analysis. To summarize, alternative dispute resolution is beneficial for various reasons. The three primary reasons any party should strongly consider ADR before pursuing litigation are specific to the cost effectiveness that goes into ADR. It's more affordable and will cost much less than paying for a lawyer to see a case through to trial. It's also private. Any party who does not want their information being public, like all court proceedings are mandated to do, are at the benefit of confidentiality with ADR practices. And finally, the amount of time spent engaging in whatever form of ADR is chosen for the parties is extensively less than the amount of time it will take for a case to see a judge and reach a verdict, sometimes years in comparison to days. For my ADR case study, I've chosen arbitration. The case study I have chosen to analyze today is focused on arbitration and is utilized from a European artist in a European art gallery, showcasing the artist's work. There was a WIPO agreement in place with an arbitration clause included upon the initial signing of the agreement. After 3 years, the relationship between the two parties was in bad shape, and so the artist terminated the initial agreement. When the artist did this, the art gallery initiated arbitration proceedings in a three-member tribunal, and the award was to the art gallery, reaching a settlement and terminating the cooperation agreement fully, as well as receiving a number of works by the artist to the gallery. The proceedings for the art gallery were swift and helped both parties reach a settlement that awarded the gallery with the works as well as honoring the artist's desire to exit the agreement. Both parties were more than likely not totally satisfied with the final result. However, the art gallery was able to retain some of the original contribution works and settle on the provision agreed upon. Thus, the artist is free to navigate their creative future outside of that gallery, while the gallery is still able to retain its works provided in the initial agreement. And that is the conclusion of my presentation today. Thank you so much for listening.